Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
The Court of Appeal has has a wide panoply of cases that it has to decide. Many have very grave ramifications. There are death penalty cases, or people with life without parole. There are custody cases involving parents' rights to over their children, and then we have cases about whether you should have cut down my tree or not. And I wonder if that factors in. You get those decisions, those cases sometimes, and say, oh, another one.
Well, one thing that is really enjoyable, going back again to when I was on the on the trial court in law and motion, I was kind of on the bubble, because if I read something in the Chronicle or the East Bay papers on Thursday, I might well have an ex parte application on Friday relating to that. And one thing, you mentioned trees. Berkeley in particular is tree central for tree lawsuits. So I got a lot of those on the court. And then you also find on the Court of Appeal that you see the trends as well. If you go to the old, any of the old digests, you'll discover that there's a huge number of cases involving ladders, trees, and fences, because that's what people get involved in their neighborhoods. And then on the other end, you get big questions of policy, and the really enjoyable work on the Court of Appeal is to get a really great policy question that you get to think about and argue with your friends about and maybe influence. I mentioned the California shooting, the 101 California shooting. That was one that allowed us to debate at great length what gun control could look like, and this was 20 years ago, more than that. Another thing that people don't particularly realize is that we give up our First Amendment rights to go on the court. Essentially, you can't go around talking and advocating, and you should not. For example, I was never a member of the Sierra Club because their cases would come in front of me, even though I'm an avid outdoorsman. But a good story on the other side would be that I wrote an opinion overturning the divorce settlement of Barry Bonds, which you may recall, which was a little bit off the ranch, because we interpreted strict scrutiny into a statute in order to overturn his divorce settlement, promptly reversed by the Supreme Court. But I took a copy of the opinion that I wrote and wrote FYI on it and sent it to somebody in the state Senate, and the law was changed. Another example of that would have been in the 101 California suit. At the time, I wrote a concurring opinion pointing out that the legislature had passed a civil code section that said that manufacturers of firearms cannot be held liable, period. And once again, I took a copy of our opinion in that case, which was the result that we were forced to reach. And I sent a copy of that to the Speaker of the House, or the Speaker of the Assembly at that time, Don Barada. And that code section was rescinded. So, and that's not advocacy, that's just for your information, legislature. And we have the ability to comment on the law, which is important.
Well, that's interesting, because we lawyers see that from time to time in the opinions, where we'll conclude there will be a topic about the separation of powers, that, well, while we sympathize with the appellant, this is a policy proposal that only the legislature can make, and we're not a legislature, so but we suggest that the legislature take a look at this next time it's in session, that sort of thing. Whenever we lawyers see that, should we? Is it safe to assume that maybe the author of that opinion is sending a copy up to the legislature?
Well, possibly, because, like I say, it is part of our job to educate and bring attention to that. When I was on the law, when I was in law and motion, I would frequently tap on the microphone for the reporting transcript and say, "Court of Appeal, this is an interesting issue. And the lawyers in the audience always like that. And occasionally they listen as well.
I've never heard that done, but that's I like that idea. You can punctuate the record that way.
Yeah, no, I often encourage people to appeal me, more than once, saying this deserves an opinion. One thing that I run across now as a rent-a-rabbi in the evaluation world is that there are areas where people will make arguments, and they'll say there's no authority, and the answer is, well, nobody ever brought it up. And there should be an opinion on this, or it wasn't needed because you're wrong. It's so obvious that you're not going to find authority because nobody's ever going to bother to appeal.
You're so obviously wrong, or you're just brilliant and no one understands.
Yeah, and by all means, if we can't settle it today, go ahead and file your appeal.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.